Good afternoon.
Your leadership, with your concurrence, was accuracy. And in this petition, 565, petition, friends, Elisha Ongoya, Tom Macharia, whose brief is being held by Ochio Dudley, Sonia Victor Ogeto, Ochio Dudley, Faith Waigwa, Willis Echeza, and John John. That is the team appearing for the petitioner in this petition. Thank you.
We note that the court was gracious enough as to give us a quorum sheet. We wouldn't want to engage you in that exercise again.
Thank you. Yes, let's mention it. Yeah. The record.
We are together with my learned senior friend, Mr. Paul Nyamoli.
My name is Muthomidi Nkolu. I appear for Professor Kibure Kindiki. I'm assisted by Mr. Eric Muriuki and Mr. Moreru Boniface Mawira.
For the first respondent, with the Speaker of the National Assembly, my learned colleague Gumbo, the dedicated does appear, but for the record, my learned colleague Gumbo and his colleagues appears for the second respondent. My name is Malord Milimo. I appear jointly with my learned colleague Mr. Kuyoni and Mr. Wanyama for the first respondent with the Speaker of the National Assembly. So, I am the 54th petitioner, Emmanuel Elijah Ocheno, and I am appearing in person. 54th petition. In petition 586 of 2024, for the petitioner Joseph Enoch Aura.
Petition number.
Petition number 586.
These petitions were consolidated. Is it?
My client was not at that stage present. In the application, because of the directives of the Honorable Chief Justice through my client's petition, so that your leadership and my lords, even the issue of the Court of Appeal, and I'm sorry to bring this at this stage because the issue has arisen. The decision of the Court of Appeal, as it were, repudiated all those other decisions based on
My Lord, I thought this stage.
His petition.
My lords and my lady, for the third petitioner, my name is Mugen, and I appear together with Mr. Sakimpa.
565.
Mr. Kuyoni and
Mr.
Kuyoni? For which party?
For the 8th respondent, the Deputy Speaker of the National Assembly.
Is there anybody left out?
Appearing alongside my colleague,
Gachuri?
Kachweri.
Gatwiri?
Kachweri
Where is she?
is present. Our petition is E599 of 2024. It was initially filed in Eldoret. We have granted the orders for consolidation. For empanelment, sorry. However, it has been appearing on its own. And we did receive communication that it will be mentioned together with E565. So we are seeking for the direction. Sheriam Tan.
Are you an advocate? Who is Shadrach?
Shadrach Omboy, the ninth petition, I believe. The ninth petition, yes.
He's an
You are an
The
advocate.
Consolidated petition.
Are you a party or an advocate?
I am I'm an advocate. And I'm also a petitioner. But I'm holding Shadrach Omboy's brief. Shadrach Omboy does not appear in person. Shadrach Omboy yes. Sheriam Tani and Shadrach Omboy is not Shadrach Omboy, I believe. Those are two different persons.
Yes.
Without the no mention directions,
For completeness of the record, on behalf of the respondents, we'd like to indicate that we have no objection to the amendment sought by Learned Senior Counsel on behalf of his client.
My Lord, let me give you a great information. In petition 586, dated the 28th of May, furnished to the court. And,
Mr. Kinyanjui,
yes,
your petition consolidated.
it was not originally consolidated.
So why don't
Hold
you?
on, hold on. When we appeared the last
Yes.
time, it was the view of the court that we await the outcome of the Court of Appeal decision. When I wrote to address you-
Mr. Kinyanjui,
Yes.
we are addressing petition E 565 of 2024. If your petition is not consolidated here, please, you'll come. We'll give you time to address that issue.
Once you're done? Yeah. Allow me, just one.
Yes.
Because I want clarity.
Yes.
On the way forward.
And said that to add that this court ought not to make us superfluous order. The reason is that you already gave directions, was granted to the petitioners on 25th of October 2024. Specifically, the petitioners were granted 5 days to amend their petition, the opportunity to respond accordingly. And it will amount to making us superfluous order if we issue another order. Perhaps the best order is to just extend time. They comply with that order within timelines, similar timelines, so that for the respondent, they can respond and take this petition to the next level.
And an amended petition was filed on 4th of February 2025. So that leave has served its purpose. Following fresh instructions as communicated, the Learned Senior can further amend the petition. So it's a fresh instruction to amend the petition to cast the case differently.
That we are in the process of uploading an update of urgency that has a bearing arising from the determinations of the Court of Appeal. I believe that will be addressed separately just for purpose because we were hoping we would have been done with it, and we are not done with it by now, just to inform the court that it is being uploaded within the next 30 minutes. Number two is that arising from what my learned senior, Mr. Paul, 40th petitioners will also need to amend their petition accordingly so that it reflects the current position. So we would also seek I believe we can do that within 14 days on our side. No, within 7 days after we have seen the proposed amendments. Within 7 days after we have seen those proposed amendments. So we seek leave to amend that petition. It was originally 570. It was filed as 570.
What we may want to just take curiously, note of, is the fact that we are asking for 14 days. If my learned friend intends to amend his petition, I believe he got his instructions independently. There's absolutely no bearing in our understanding between what learned senior Mr. Paul Mwite will be presenting to his client and what they await to inform, unless they're saying there's a correlation that we don't understand from under the table, but we don't want to go there. We think we should just have it capped in terms of time.
And to confirm, there's an obvious, so there's a direct correlation. There's no secret about that.
Mr. Kibe Mugai wanted to amend his petition. And Mr. Kibe Mugai's request for amendment was accompanied by a request that he wanted to convene a baraza of the petitioners so as to understand where they were. Now, the journey of this matter through the Court of Appeal has given Mr. Kibe Mugai, his clients, and anybody who wanted to participate in that baraza sufficient time to convene. No precious judicial time should be taken for petitioners to look at what other petitioners are filing and then amend their petition. If this court is minded and we do not object to the court giving the petitioners leave, let it be a blanket leave to the petitioners for them to file by a certain time, not sequentially, once and for all.
Well, very much we over, and that's why we are proceeding with this section of the. Of course, we had given directions on amendments of petitions, but we understand that circumstances have changed, and the petitioners may want to further amend their petitions. That should not be a difficult prayer to answer, and therefore, even as we adjourn.
Yes. My Lord, and we are apprehensive that this matter will never take off, be determined at a substantive level, and even as you reflect on the directions you give, it is our very humble request that the court should rein in the parties. We can't keep moving one step back, two steps forward, two steps forward, one step back. So I beseech the court to have the hearing in mind as you give us directions on the way forward, so that if anyone wants to file anything, that you should also, I request you commit them to a timeline within which to do it, and more importantly, with the determination of any of those interlocutory applications in mind. And the reason I make that request is I say, my client is apprehensive. We will never move. We'll just keep doing the pebble and being I told you earlier on.
Thank you.
E565, whom we represent, is not filing and does not intend to file any interlocutory application. Number two, with regard to the apprehensions that the petition may not proceed anytime soon, it is the prayer of the petitioner in 565 that this honorable court gives us the earliest possible date for the hearing of the petition on the merits. Finally, it is in fact the petitioner who was the subject of impeachment. His petition is not purely in public interest. He has got a direct interest because he's the one who was impeached. It is him who endures the adverse effect. So, those apprehensions have no basis. And we are not asking for more than 7 days to amend the petition to align it with the current instructions from the petitioner.
Thank you. Mr. Kinyanjui will address your issue when.
The intention of all the parties is to have this petition concluded in the earliest possible time. My Lord, the effect, wittingly or unwittingly,
petition that suffered the e-filing breach when I believe you are dealing with the issue on vacating non-arbitrary orders. And I think that's why then it was a standalone petition. Our leadership, the Honorable the Chief Justice, gave specific directions because we had asked for a 5-judge bench. And my lords and my lady, when we were then finally referred to the bench, you had made significant advances in having all the parties come together. And when we appeared now for the first time, the last occasion, I did inform the lordships, my lady, that the intention, I think there is an issue with lordship.
Yes.
I did indicate the intention of my clients, just as Senior Counsel has indicated, the expedition in the settlement of issues. One or the other, the petition will be determined. So, the appeal before the Court of Appeal, which your Lordship has alluded to, was determined in a material way where the intervention of the Honorable the Chief Justice again was invoked and it was brought to bear. Now, the peculiar aspect of petition E586 is that her leadership had communicated to my client in very specific terms because of the plea for a 5-judge bench. Now, we have filed the motion dated the 28th of May 2025 in deference to that particular direction of our leadership. And also, within the context of, I'm just laying the context of the application so that then your leadership, my lords, then can see how this can be disposed of. Why do I say that? Because it implicates the Constitution.
The date of the motion?
28th of May. The motion is dated 28th of May. I did furnish the court with a hard copy of the motion itself. Now, that particular communication...
You have already filed it, eh?
I've already filed.
Yeah, I think that's what I saw online. Yes,
Yes, I did file it. Now, at page 30 of the motion is the particular communication from our issue, the Honorable Chief Justice. Now, if you were to peruse, and I was very kind enough to serve all my letter friends that are before you with the application. If peradventure any of my letter friends had not received, I did not have their email with me. But anybody that I was able to access their email out of professional courtesy, I gave them. Now, at page 30 of that motion is that particular communication from her leadership, the Honorable the Chief Justice. And in the last paragraph of that particular letter, which she wrote dated 23rd of January 2025, she has specifically said that the instant motion be framed and tabled before your leadership. So, in line now with the Court of Appeal direction, so we did request by a specific letter dated the 22nd of May 2025, which also we have produced a copy of, that her leadership then is able to reconstitute the bench in line with the Court of Appeal determination. Now, may I say at this point, I did not receive the email communication from the Honorable the Deputy Registrar of this division of today's hearing. When, at the time I was filing, I only became aware that, in fact, there is a listing of this particular 565, the lead petition in the consolidated petitions. And the Honorable DR then sent me an email saying that we would appear before your lordships at 2:30 p.m. today. Which is why then, my lords and my lady, I would prefer that we get directions on this motion, because it materially implicates what this particular bench will then do. The deference to her leadership, the Chief Justice directions, we need then reconstitute, we need order and reconstitution.
What are the specific prayers you are urging in that application?
Yes, we are urging your, if I may just refer you to the particular please, prayer number 1, prayer number 1, I believe so. Prayer number 2 and 3, at page 19 and 20. May I read very quickly?
Yes.
Yes. Now, paragraph 2 says that pursuant to the directions of the Honorable the Chief Justice of Kenya, by her letter to the petitioner hearing, dated 23rd of January 2025, in the instant petition, this Honorable Court be pleased to certify the amended petition herein, as amended on the 18th of December 2024, raises very weighty and substantial questions of law under Article 165(3)(b) or D of the Constitution of Kenya, and thereupon, pursuant to Article 165(4) of the Constitution of Kenya, this Honorable Court be pleased to forthwith refer the amended petition to the Honorable the Chief Justice of Kenya for the empanelment of an expanded bench of an uneven number of judges of not less than 5 judges. Now that again goes to page 30, the last paragraph of our communication. Now in paragraph 3, we have sought, and this is with tremendous respect to the bench, pursuant to the directions of the Honorable the Chief Justice of Kenya, by her letter to the petitioner hearing, dated 23rd of January 2025, the instant petition, the Honorable Court be pleased to grant the petitioner applicant's plea that the bench hearing, comprising of now the Honorable Rima J, Honorable E. Ogola J, and Honorable Lady Justice E. Mugabe, forthwith ceases to hear and determine any aspect of the amended petition hearing, in brackets, and all ancillary related petitions arising from the same cause of action, which meant, as I was framing this particular plea, any cause of action outside what we are seeking here post the swearing in of the 10th respondent, Mr. Tiankolu's malaria client, ancillary petitions to the Honorable the Chief Justice of Kenya for the reconstitution of a bench of not less than 5 judges, excluding the state learned judges, the Honorable Rima J, Honorable E. Ogola J, and Honorable Lady Justice F. Mugabe. Now we seek, and this is also why my lady and my lord, I sought to bring it to your attention, that pending the hearing and determination of this motion, the proceedings in the amended petition hearing, and if you elect, and the ancillary petitions under the same cause of action be stayed. Now, so that I close. This derives from the Chief Justice being the head of the judiciary, giving us specific directions, which, as I've indicated, by the letter dated 22nd of May 2022, which you've also produced as Exhibit EAJ 4, she has not negated, repudiated, or otherwise recalled those instructions. When we ask her, refer to a communication dated the 16th of January 2025, tied and as read with your response rejoined thereto, dated the 23rd of January 2025. So she hasn't changed that position with respect. So that, my lord and my lady, in light of that context, I would urge the court then to give my application priority, so that then we can get a way forward. Because it is her leadership, the Chief Justice, that gave us that way forward. Thank you. That is Cape Mountain. One of the issues that we have raised here also in the motion, because my lady, my lord asked, what is the implication of the judgment of the Court of Appeal so far as the constitution of the Honorable Bench is concerned? If indeed we accept, and must, that the unconstitutionality of the appointment that gave rise to the bench, having been decided in the manner it was, in fact, decided by the Court of Appeal, so that her leadership then had a quote-unquote, the opportunity then to reappoint. Does that act, does that decision, does the verdict of the Court of Appeal invalidate any and all decisions that your leadership and my lords made prior to, antecedent to the decision of the Court of Appeal? We have also raised that issue. So that then the decisions you make, my lady and my lords, with tremendous respect, are not tainted with that little issue, so that then in the end, everything that the bench does is vitiated.
Number 586. our client shall not be participating in that petition. I want to make it very clear. Impeachment proceedings that took place in the National Assembly and the Senate and are now before this court for determination. In the circumstances, our client leaves that question completely to the hands of this court and shall not make one suggestion or the other to it. But whatever directions are given, our instructions are that they should not impair the expeditious hearing and determination of petition number 565, which our client is willing and able to come back and argue as soon as the amended petition is put on the file as earlier requested, and for which we are awaiting this court's directions.
Occasion.
Those causes of action, once and for all, with finality.
My Lord.
We are running out of time.
Yes.
We are running out of time.
Be brief. Now we also have another petition that is not consolidated. That is petition number E576 that we will be seeking to be consolidated within this particular cohort. Secondly, my Lord, we wish to get your directions on withdrawals of petitions with regards to petition number 522, which was withdrawn and was consolidated in the first petition. We also seek directions on those particular withdrawals.
In parties who have come and objected to withdrawals, and we have asked them to serve. So we have had your submissions on the issues before the court.
Before you make your directions, I wanted to...
That's Honorable Jerry Minor. My Lords, when we talk about the consolidation that was done previously, and consequent to the ruling by the Court of Appeal, that decision for consolidation was done by the impugned bench. Are we relying on those consolidations, or is this now a newly reconstituted bench that must reconsolidate? We need clarity on that.
Technically, any one of us, either genuinely or mischievously, would at whatever time prop up with an interlocutory application, taking us back. And why we are apprehensive about this application and the potential of similar ones, although today is not the date to argue the application, when you retreat, I will urge you to look at it on its face. This is an application revisiting issues already resolved by the Court of Appeal. This court is not the forum to seek an interpretation of the consequences of the Court of Appeal decision. So it must follow, then we must question whether it is prudent use of your time to entertain applications like this one before you and future potential ones. And I'm saying this from practice, my Lord. I've been previously involved in cases where you have 30, 40, 50, 60 parties. It is for that reason that the court is required under the relevant rules to take control of the process. Because now we will come and argue this application. The prayer he's talking about is addressed in paragraph 212, 213, and 214 of the Court of Appeal decision. That decision is a decision in rem. It binds everyone, including those who are not even party to that appeal. And that's why we beseech you, my Lord, as you reflect when you retire, for us, as far as we are concerned, the apprehension is there is a scheme. Sometimes people playing good cop, bad cop, to ensure this matter never moves. And we even urge you, as I sit down, if it is possible, if it finds favor with you, because we might also sit here again until sunset and whatever, you could actually even send us your directions via email.
Your Honor, allow me to just make one statement also for the Speaker of the National Assembly. Your Honor,
is always resorted to they who have no other arms by means of which to attack. They've exhausted everything. So they have to go to ad hominem, attacking your tie, attacking your suit, attacking your language. Let me reserve everything else I have to say.
He's also attacking the judges in their
No.
My daughter and my lady, I have tremendous respect. In fact, if my learned friends have read this application, everywhere the learned judges are referenced, it always starts or has a with respect. In parentheses, if I should say. Oh, let me just say this so that I close. Number one, this motion is not mounted so as to defeat in any way the course of hearing of this petition or the petition. Secondly, I said that Article 161, Sub-Article 2A of the Constitution confers upon her leadership the Chief Justice of this country to issue whatever directions, whatever is as the head of the judiciary. So that when my learned friends say and allude and try to insinuate that this is a mischievous application, or as Mr. Muthoni says, that probably is shown in bad faith, it is not. It is because of that. So that everyone has a right to be heard. And Article 48 of the Constitution does confer on everyone the right to access justice. If my learned friends want to have a rejoinder, I beg that your lordships, my lady, then can give directions. And then we can have the arguments on merit based on your directions. Thank you.
Thank you. We give our We have considered the various applications made as well as the submissions by learned counsel. The main issue arising is in the application for leave to the said application. Accordingly, 1, leave is hereby granted to the petitioners to further amend their respective petitions, if need be, within 7 days from today. 2, leave is also granted to the respondents to further amend, as the case may be, their respective responses in the petition, also within 7 days of service. 3, taking into account the public interest issues in this matter, the gravity of the questions raised, and the positions taken by parties towards an expedited determination of these petitions, all pending applications, if any, shall be heard together with the petitions. For the avoidance of doubt, this includes any pending applications for withdrawal of petitions. In this regard, this matter will be mentioned again for compliance and for further directions on the hearing of the petitions on 19th of June 2025 at 2:30 p.m. Further directions are as follows. On the request as to whether there will be a reconsolidation of the petitions, we hereby direct that the previous directions on consolidation shall stand and be in force. In this regard, all other petitions filed are subject to the directions, to the early directions on the manner in which the petition shall proceed, and for avoidance of doubt, those directions have been uploaded on the CTS. Thank you.
This counsel for the parties on their respective proposals on the way forward in this petition, and noting that this petition is not amongst the consolidated petitions, the following directions hereby issue. Number 1, in order to allow the petitioner room and the latitude to fully ventilate his case, and noting that the first interested party has indicated that you will not be participating in this petition, and further noting previous directions issued by this bench to the effect that petitions not consolidated in the first and second cohort would await the determination of the consolidated petitions in cohort 1 and 2. We review these directions in view of the uniqueness of this petition and allow it to run on its own. As such, the motion dated the 28th of May 2025 shall be served and responded to within 14 days of service. 3. Thereafter, parties shall file their written submissions within 14 days each, beginning with the applicant. 4. Leave is granted to the applicant to file any further rejoinder within 7 days of service. And 5. Highlighting of submissions on the 8th of July 2025 at 2:30 p.m. Thank you.